Hello, Ngozi. Good to see you.
Good afternoon.
Ngozi, can you hear us? Good afternoon, everyone. Welcome to today's session of the IP series of the Practical Training Academy. Thank you very much for joining, and thank you all for having been part of the training series in over the period of 4 days that we've been on with this. Today, we'll have a special guest who's come to speak to us, and she's joining us all the way from the United States. One of the leading experts in IP law in Nigeria, Mrs. Ngozi Aderebimbe. With over 17 years of experience in niche areas of law, Ngozi is highly regarded by our clients and contemporaries as a leading expert in intellectual property, privacy and data protection, and technology advisory. Ngozi's career is a testament to versatility and excellence. She's a trusted advisor to high-profile regional and international clients across diverse industries, including telecommunications, technology, media, and entertainment. Her specialties include intellectual property transactions. Ngozi has been involved in some of the most complex intellectual property transactions in Nigeria. She advised one of Africa's leading stock exchanges on its intellectual property structure in the face of a major corporate restructuring, exemplifying her ability to navigate complex landscapes. She has led her team to carry out several intellectual property audit exercises on complex IP portfolios, including those of one of Africa's leading telecommunications companies. With her superb legal drafting skills and business savvy, she's excellent at negotiating, drafting, and advising on a wide range of IP agreements. Technology and creative industry. Ngozi's work in the technology and creative sector includes acting as production counsel on several notable film projects, including Netflix and Amazon original projects commissioned in Nigeria. She advises a diverse range of tech firms from startups to transnationals and actively participates in technology policy discussions and the Nigerian legal landscape's impact on digital currencies. You know, I remember a training session that Ngozi handled for the MBA on HR, and I thoroughly enjoyed that training session, and especially when she told the story about the acquisition of Rolls-Royce by Volkswagen and BMW, and I hope she finds a way to tell that story today. So, yes, just before handing over to the moderator for the day, I just want to introduce also Ntai Bikenbang, who's going to be moderating, and Idris Mohammed, our Chief Operating Officer. As time goes on during the session, I'll advise that people shouldn't just throw in stuff on the chat box. Indeed, I'm going to instruct that they close the chat box and just keep our YouTube channel link there so that people can join in. And then I'll now hand over to Ntatu to generally coordinate the affairs of today. Thank you.
Hello, everyone. Thank you to Bena for the brief introduction. Ngozi, so what we're going to do is you're going to have the floor now. Please, can everyone put the questions as Ngozi goes on in the Q&A section. When you're done with the presentation, hopefully, we'll have at least 30 minutes to, and I'll come back and read out the questions, and then we'll take it on from there. So also, Idris, when we come back for the Q&A session, if you have any other comments or anything, we will take, the comments or anything at that time. So for the YouTube, all our presentations, during this series and all of that series of the Practical Training Academy is on the YouTube channel. So Tobina, please, if you can, that be posted so that everyone can follow. If you need to watch this session again and all other sessions, it is on YouTube. So Ngozi, if you're ready, we're ready. If you can share your screen and take it on from there. Yeah.
Thank you very much, and thank you to the organizers, particularly for inviting me here. Thank you. It's my privilege to be part of this training session. I will share my screen shortly. Just give me a second. You will see my screen. Can you see my screen? Just a confirmation.
Yes, at least I can, so
Great.
everyone else should be able to see it.
Okay, thank you. So good afternoon, everyone. Good afternoon, colleagues. I am delighted to be your facilitator today, and we are taking a very interesting journey into the world of copyright. In the past few sessions, we've touched on different aspects of intellectual property, but I can tell you copyright is the source of intellectual property. It's the most interesting part. My name is Ngozi Aderibigbe. Now, before we get into the nitty-gritty of copyright law or intellectual property, let's even understand what property means. I'm skipping the content because, well, okay, I think I should just show it. This is what we'll be covering. We'll talk about introduction, what is copyright, nature of copyright, conditions for copyright protection. We will delve into the tricky issues around authorship and ownership. We'll touch on performance right. We'll touch on copyright infringement, and we'll talk about duration, and we'll call it a wrap. The whole point in this presentation is to introduce you to the concept of copyright. Copyright is such a deep and wide subject. And I'm confident that after today's session, you will have a good grasp of it and you would have an interest in learning more about copyright. Let's start with introduction. Let's talk about property, right? Generally, we all own property. Your phone, your book, your wig and gown, your movable property. These are stuff that you carry around. These are things that we call movable property, and that's one form of property. Then we have property that is immovable, like your land and houses. I know when you moved from Akure to Abuja, you were wishing you could move your house with you, but you couldn't because it's immovable. It is property that is fixed. And then we have the third type of property, which is the crux of today's conversation, and that's intellectual property. Intellectual property is property that is recognized by law, it is conferred by law, and it's basically for the purpose of protecting creations of human intellect. I don't want to go into depth on that because I know by now you are pros in intellectual property generally. So let's narrow down very quickly to copyright. Now, copyright is a branch of intellectual property that protects the interests of creators. Now, when you think about property, one question that I'd like to ask is, how do you know what you own? Someone might say, oh, I paid for it. Well, you paid your rent, it doesn't mean you own the house. So that you paid for something doesn't mean you own it. I think generally the fact that you're even in possession doesn't mean that you own a thing. I think we know that as lawyers. The determinant for ownership is actually what we call ownership rights, what kind of rights you can exercise over the subject matter. And in this context, as we uncover copyright, we'll begin to see that there are certain rights that copyright confers on intangible property that gives them the same quality as any other property. But as relates to the creative industry, which is the focus of our session today, it's an introduction to copyright, but we are contexting it, we're putting the context within the creative industry. As it relates to the creative industry, I like to think about copyright as the hub that connects the hub that connects the different strokes of the wheel of the creative industry. Because without copyright, the spokes of the creative industry will not come together and you will not even have a creative sector. It is the framework that takes creativity from just being an expression of human, creation to becoming a subject that we can build commerce around, we can have an industry around, we can exchange value for. The only reason that happens, or that can happen, is because of copyright laws. Without copyright laws, creators would have little or no incentive to invest their time, their money, and skill in producing those high quality works that we enjoy. When you sit back to watch a film on Netflix, someone put in creative, I mean, it's not just creativity you're watching, you're watching an exchange of commercial value. You've paid something to be able to access that content. And that's how the creative industry works. And so we would look at creativity in the context of the economic value that intellectual property enables it to yield. But let's start with a basic question. What is copyright? Think of the word copyright. What exactly is copyright? If you break down the word, let's not be technical. Just think about like if you were a primary 6 student. Copyright could mean the right you have over a physical copy of your work. If you think about it, copyright. It could also mean the right to make copies of your work. Copyright. It could also mean the right to copy correctly, copy rightly. The interesting thing is, while it could be a play of words, the truth is that copyright has all of these connected. All of these are connected to copyright. So copyright has elements of the right to copy, the right to ensure that you can prevent others from copying, and the need to copy correctly. But generally, we'll describe it as a legal term that is used to describe the rights that creators have over their creative works. Still on this question of what is copyright, I particularly like this quote that was adopted by the court. I believe it was the Supreme Court in Ubom and Globacom Limited. And it's a quote from Paul Goldstein's Copyright Highway. That's another case, but it was quoted in this Nigerian case. Basically, it says, from copyright law's beginnings, close to 3 centuries ago, the term has meant just what it says, the right to make copies of a given work. At first, it simply meant written work, but now it has expanded, and we'll talk about it. And it means the right to stop others from making copies without one's permission. This perhaps will be our go-to definition today. It's a definition from World Intellectual Property Organization. And they have described copyright as the exclusive right granted by law to the author of a work to disclose it as his own creation, to reproduce it and distribute it or disseminate it to the public in any manner or by any means, and also to authorize others to use the work in specified ways. That's the definition from WIPO, World Intellectual Property Organization. I highlighted 2 things there. Number 1 is exclusive rights. You would know by now that intellectual property rights are all exclusive rights. But what I want to highlight, apart from the phrase exclusive right, is the fact that copyright, like other intellectual property right, is defined by law. So even though we say intellectual property right protects expressions of human creativity or creations of the human intellect, those creations are only protected to the extent that there is a law that prescribes their protection. And so you will find that there are certain things that, in fact, may be expressions of the human creativity, but may not be protected by copyright. I will look at all of those things as we move along. So let's start with the nature of copyright. Some of these would already have been covered when you were having an overview on intellectual property law, but I think it's still good to have a full conversation around copyright, connecting the dots from the beginning to the end. Like I've said, copyright is defined by law. It is a statutory right. It is not a common law right. In Nigeria, everything about copyright is as defined and as prescribed by the Copyright Act of 2022. The other thing to note about copyright is that it has territorial limitations. And this is also common to intellectual property rights. So if you have a copyright over a work that if your work is protected in Nigeria, it is not automatically protected in other countries. However, as I would explain, there is a treaty that allows for copyrights to be protected in almost all the jurisdictions of the world. But there is still the notion that intellectual property rights, including copyright, is founded in national laws and is therefore territorial. It is limited is limited to the country. And the reason is simply this. Like we said, it is a statutory right. It is conferred by a national legislation. There is no national legislation that can have reach outside the country, and so it is by definition territorial. Copyright also confers two types of rights on authors: economic rights and moral rights. And don't worry about understanding these terms now. We have some time going into the slides to talk about each of these rights. Copyrights are exclusive. Copyrights are conferred automatically. There is no formality required. Now, let me pause here to explain this. When you think about trademark rights, you have the common law trademark rights, which you begin to acquire when you begin to use a trademark. But for you to get the statutory trademark rights, which is a superior kind of trademark rights, you need to register it with the trademarks registry. So registration gives you a statutory right. But that's not the case with copyright. With patent as well, registration gives you the right to a patent, registration of your invention. But that's not the case with copyright. The moment your work qualifies for copyright protection, without you moving an inch, lifting a pen, going to see anybody anywhere, you have automatic rights in that work. Now, I would also explain here, because I know some questions may have come up in your mind. Oh, but I've heard about registering copyright works with the Nigerian Copyright Commission. Yes, that is correct. Now, what happens at the Nigerian Copyright Commission is a notification. You are simply putting in a notification that I own this copyright and I want it to be on public record that it is mine. And so it is not the deposition of that work at the Copyright Commission that creates the rights. The right exists in itself, and you just want to provide public evidence and reference for any, should you have to defend your rights to it, you can then call on NCC as a public custodian to prove that indeed on XYZ date, you notified them that you owned the right. But for all intents and purposes, let it be settled in our minds that copyright is automatic. It requires no formalities. The next point is that copyright confers on a work without any reference to the quality or the utilitarian value of the work. The work doesn't have to be one that has such a qualitative value that, oh, I wrote this poem and anyone who listens to this poem, their lives will change forever. It doesn't have to get to that point. As long as it meets certain conditions that we would discuss, it doesn't matter if it has no useful value. It is copyright protected. And of course, like you already know, copyright is an intangible right, even though it may be embodied in a physical property. Now, let me explain this. When we say copyright is intangible, like any other intellectual property, it's not what you can touch or see. It's a right. It's not a physical thing. but it might be embodied in a physical property. I could, for example, write a song, and I have my song on a manuscript. The manuscript is a physical embodiment of the song that I created. However, that creation was a mental exertion. It was my creativity. And the right that the law gives to me is not the right to the manuscripts, as it were. It is, in fact, the right to control the content of the manuscripts, to control the intellectual property contribution that I have made in the field of poetry. So copyright is a property right, but it is different from the property in a physical thing. If I buy a book from a bookstore, I will own the book and I can do what I like with it. It is a physical object. I can read it, I can stand on it, I can throw it in the garbage, I can do whatever I like with the book. But someone else will typically own the copyright in the book. So even though I can tear the book, but guess what I cannot do? I cannot make photocopies of that book. And the reason I can't do that is because, as we would see, the law prohibits me from reproducing the work, the intangible work of another person. There's a case that I'd like to highlight to drive home this point. Charles Dickens. If you're in my age group, you know Charles Dickens. He's the author of Oliver Twist. But Charles Dickens, when he died, he had a manuscript that was titled The Life of Our Lord. And he left this manuscript, in his will, he left the manuscript to his sister-in-law, Georgina. And the words he used to bequeath that property to her are private papers. It was described as private papers whatsoever. So she had, she was basically getting a bequeathal of all his private papers whatsoever and wheresoever. And of course, this manuscript was a paper, so it contained the life of our Lord. But then he also gave his residuary estate, which as lawyers we understand to mean any other property that wasn't specifically gifted, right, or bequeathed rather, would fall under the residuary estate. And so his children had the residuary estate. Now remember, the manuscript was bequeathed as a paper, as private paper, right, as a tangible thing to his sister. And then at some point, his sister wanted to make copies of the manuscript, to publish the manuscript. And this issue arose. It was then an issue of whether she had the right to reproduce the manuscript. And it was a good opportunity for the court to determine whether copyright in a literary work, copyright in a work that has been expressed literally, whether it passes along with the manuscript that contains it. Think about it. You can't even reproduce the work without the manuscript, right? You need the manuscript. But interesting issues in copyright. The court held, and rightfully so, that the literary work, the copyright in the literary work is distinct from the rights to the manuscript. And so while Georgina had inherited the manuscript, she did not inherit the copyright in the manuscript because Charles Dickens did not make reference to copyright in the language used in his will. And so the bequest of his personal estate passed all the copyrights, which were now part of this residuary estate, to his children because they were not expressly granted. I think that's an interesting case that just highlights the important difference between the rights to the copyright work in itself and the right to the manuscript, the embodiment of that work. Now, the next question is everything copyright protectable? I already said before that the law prescribes very clearly that certain things are not protected. So it's only the things that are specifically and clearly prescribed by the law that will be protected. There are generally 4 conditions that any creative work must satisfy in order to be protected under the Nigerian copyright law. The first is that the work must be eligible. We will discuss what it means. This just means that the work must fall under one of the recognized classes of works under the Act. And we'll come to that shortly. The work must be original. Is it truly your own expression? That's what the law is going to be requiring. It must be fixated. This just means that it has to be captured in a tangible medium. And then there must be a nexus to Nigeria. Is there a relevant connection to Nigeria? Each of these 4 elements we'll now discuss, starting with eligible works. The Copyright Act in Section 2 gives an exhaustive list of works that can be protected by copyright. Exhaustive, that's important. You can't add to this list. So if it's outside of this, then it will not be protected by copyright. What are these lists? Literary works, musical works, artistic works, audiovisual works, sound recording, and broadcast. Let's start. Okay, before we look deep, before we examine each of those works, let me highlight to you some of the works that will not be protected by copyright. And under the current Copyright Act, which is a remarkable difference from what we had before 2022, there are clear provisions on what is excluded from copyright protection. And the first one, it will surprise you, is that ideas, no matter how brilliant they are not protected by copyright. You might have the idea on how to create a flying car that can beat Lagos traffic. Wonderful idea. You have it well set. You know exactly what needs to happen. It might be protected under patent if you're able to work it out. But the idea in itself will not be one for copyright protection. Procedures, processes, formats. Think of procedures. Think of how you're able to make that wonderful dish, how you make your egusi soup, and anyone who tastes it, their lives will never be the same. The process in itself is not copyright protected. Something needs to happen to distill it from that level of being an abstract idea, an abstract process that you know so well, you've done it all your life, into a format that copyright will then recognize and protect it. And we'll talk about that. I think this case, let me just highlight this case here, because this is something that we can relate to. I would just perhaps talk about the case of Celador Productions and Denmark's Radio. In that case, Celador sued Denmark's Radio for creating a game show, which they called Double or Quits. And that game show had a lot of similarities with Who Wants to Be a Millionaire. Now, we all know Who Wants to Be a Millionaire, so that's why I want to use that particular case. Who Wants to Be a Millionaire is a game show. You know it because, you know, when you hear the soundtrack, you know, oh, that's Who Wants to Be a Millionaire. You see the setup, you kind of know the look and feel of it, right? And Celador wanted well, they did sue. They sued for infringement of the rights they have in Who Wants to Be a Millionaire. Now listen to this. The court rejected that claim. The court found that Celador's copyright is nothing but is not copyright in the sense that it is just an idea. It's a process. It's a format, and formats, processes, procedures cannot be protected as copyright. If you think about Who Wants to Be a Millionaire, there isn't a script. It's unscripted. Different things would happen in different episodes, even though there is a format, there is a style, there's a sound record. There are things that are like processes and procedures, but it doesn't fall within the realm of copyright protected work. And I'll tell you, let me preempt something that I'm going to say further down the line. One of the reasons is because it is not fixated. It is not like a film that has been captured in a fixated work. A format is happening as you're watching it, and therefore the court ruled that they could not protect it, or they could not succeed with the infringement claim, although the court found some other basis to rule in favor of Cellador. Other things that are ineligible for copyright protection, the official text, in fact, let me just say laws and administrative texts, they are not protected. Official state symbols, flags, anthems, banknotes, these are all excluded. I know you have some questions. Just pile up those questions. We'll have time to answer those questions. I'm definitely going to make room for us to answer questions before we wrap up today. Okay, so now let's move on to literary works. Remember that I had identified 6 types of works that the law would recognize. So the first thing to do, and I'm going to go back to those slides. The first thing to do when you have a situation is to say, can I situate this work under any of these 6 headings? If you cannot situate it, you are not looking at copyright protection. It might be something else, but definitely not copyright protection. So let's start with literary works. What are covered under literary works? The Act says literary works includes, irrespective of literary quality, any of the following, and there's a list there. You can run through the list. I don't think I need to run through the list, but I'll leave it on the slide, on the screen. Novels, books. I will just highlight a few things. Literary expressions, including lyrics of songs, which would fall under poetic works, would be protected as literary works. When you think of audiovisual works, the Act uses the word audiovisual works. In previous renditions of the Copyright Act, it's been called cinematographic films. So when you see audiovisual works, we're really talking about films. And it doesn't have to be a feature film. When you use your phone to capture a moving images, right? You're actually creating audiovisual works. So movie scripts, screenplays will be covered. Computer programs, your codes. Now, let me pause here to explain something about computer program, because I have seen a lot of people get confused about how copyright protects computer programs or software. Now, if you know the beginnings of computer programming or software, you would know that a software functions because of the codes that have been used to write the software. So coding is like writing in a sense. They're giving instructions to the computer to behave in a certain way. Now, the way we code could be different, just like the way we would write. Now, if I asked you, and I know you're paying attention to what I'm saying, but if I asked you to regurgitate what I have said, you would probably use your own language, your own expressions to say the same things that I am saying. So substantially is the same, but the way you would render it will be your expression. And that's the way it works in software programming, in programming as well. You can have software that achieves the same technical results, but the programs are written differently because no two programmers will program exactly the same. It's just like no two people will speak exactly the same way. And so the codes are recognized and protected as literary works. Choreographic works, which is defined in the act as a composition of movements for dancing, right? I imagine that this would mean you have a settled process, documentation of the movements for dancing. Textbooks, written tables, and compilation. Something else I want to highlight with that last one is that database, especially in today's world where we deal with data a lot. The database is protected as literary work, whether it is compiled in a computer or in any other medium, it is recognized as literary work. Next, let's move on to musical works. Most songs you hear on the radio, most songs you play or you listen to would be a composite of distinct copyright works, including musical works. Now, musical works means musical composition, irrespective of musical quality. And that's the definition by the law. That's the definition under the Act. So musical work is the arrangement of the melody, the harmony, the rhythm, the solfa notation. It refers to the tune, and it's different from the lyrics of the work. So if you think about any song, and in my next slide, I just realized that when I was sharing, I don't think I shared the sound. And I don't know if I have time to reshare again, but I had on this slide, I actually had, let me try it. Can you hear anything? No.
Yes, I can, but
Oh, you
I don't
can?
know if, yeah,
Okay.
I can.
So if you can hear it, hopefully everyone else can hear it. Okay. So that's a musical work. And if you know the song, you know the song. That's Stevie Wonder's Happy Birthday. But just listening to the musical composition, you already kind of know the song if you know the song. And that's distinct from the words, the lyrics that he sang along with it. And that's something that we need to be aware of. Now, if you think about musical works, in this particular case, the musical composition was by Stevie Wonder. The literary work was he also wrote the lyrics, and then the sound recording, we will come back to all of this, but it will make sense as we move along, is now under Universal Music Group. And of course, he was performed by Stevie Wonder. Each of these layers comprise separate copyright works, each of them. But like I said, we'll come back to look at those and to dive deeper into them. Still on musical works, there's a case that I'm hoping would highlight this very clearly to us, and it's Fisher versus Brooker and Onward Music Limited. In that case, Fisher and Brooker were members of the group called Procol Harum, and they recorded a song called A Whiter Shade of Pale. The song became extremely popular, and it's still popular to now. Now, things are always good until, a work becomes really, really popular and the commercial value increases. But anyway, Fisher, who played the organ on that song, claimed that his contributions, in particular to the solo that introduces the songs, were such that he deserved a share of the musical copyright. And the courts agreed with him. He didn't utter one word. All he did was to play the organ, and that was sufficient. It was considered to be sufficiently different from what had been composed earlier. So his contribution to the work was distinct because it was a musical work, recognized as such, and the court held that he was entitled to be rewarded for that. Moving on to artistic works. Artistic works includes artistic expressions, right? And some of them are listed. They're paintings, drawings, maps, works of sculpture, photographs, and works of architecture in the form of building models. I wanted to pause there because we see buildings. I remember someone close to me saw a building somewhere and said, I love this building. I'm going to build something like that. And the question was, will it amount to copyright infringement for him to do that? Well, the words that the Act uses to define artistic work in the context of building talks about works of architecture in the form of building models. Now, a model, as you know, is different from the building itself. And so the model is what can be infringed upon, not the building. Just an interesting twist there, but something to highlight, because the words and the phrasing and the language used by the law is critical in defining the extent and scope of copyright protection. I could say the same thing about fashion, but because you can see you can look at the style of what I'm wearing, and if you are a fashion designer, you can say, oh, I think I can make something like that. It would not be infringement, and these are the tricky issues around the fashion industry, and that's why I said you can have a creative expression that isn't protected by law, and if it isn't protected, it doesn't amount to intellectual property automatically. But if you have access to my sketches, the sketches that is used to make the outfit, and you copy that, you would then be infringing. Anyway, let's move on to audiovisual works. Like I said, audiovisual works simply refer to cinematograph films. And it refers to the aggregate of a series of related visual images with or without sound, which is capable of being shown as a moving picture. So it boils down to one thing: you have visual images that can be shown as a moving picture. Remember, the quality doesn't matter. So if you're at home and you're taking using your camera to capture your child, doesn't matter. It is protected by copyright as audiovisual work. Under the Copyright Act 2022, audiovisual works include the soundtrack that is accompanying the work. So when there's a soundtrack that is built into the imaging, it will also be protected as audiovisual work. However, there is a distinction to be made that if the soundtrack was recorded independent of the work, then the soundtrack is an independent work, and it's different from the film. So if you think about how we often use music to overlay our videos on TikTok, right, on social media, that music is a standalone work. The fact that you've used it to overlay your work doesn't now make it part of the audiovisual work. It is a standalone work because it is recorded differently. And I think I have something on that in a subsequent slide. Okay. I'm not sure I can expand this. The video was supposed to be bigger than this, but this is basically a music video. The music video of Pharrell Williams. And the point in that was just to show how you can have the image. What the law contemplates is you have the image and the song, and they're recorded as one work, as distinct from having two separate works where you're overlaying one on the other. Moving on, let's talk about sound recording. Sound recording means the fixation of a sequence of sound capable of being perceived orally with the ears and of being reproduced. But it does not include a soundtrack accompanying or incorporated in an audiovisual work. So it's just the flip side of what we have explained, right? If it is a soundtrack that is incorporated in an audiovisual work, then it won't be seen as a sound recording. But see the second paragraph there, a soundtrack of a film is protected as an audiovisual work. However, if it was recorded independent of the film, it will be protected as sound recording. And just to mention, all of these provisions are found in the Copyright Act. And so if you use a soundtrack, like I said, if you use a soundtrack for your TikTok video, it is identified as a separate sound recording. Now, in the film industry, there are two ways in which a song may be incorporated into a film. Sometimes you could have a composer compose a song specifically for that scene. And in that case, it is more likely that that song composed specifically for that scene will be seen as an incorporation into the audiovisual work and will be seen as one. However, if it is a song that pre-existed and is now being used and incorporated, it is going to be seen as a separate work altogether from the audiovisual work. And then broadcasting, this is the last of the 6 eligible works. Broadcasting simply means transmission by wireless means of sounds or images or both, in such a manner as to cause images or sounds to be received by the public. The thing to note about broadcasting is broadcasting is different from streaming videos on demand, because with broadcasting, the audience is receiving the transmission in real time. The audience is not determining when they would receive it. They receive it in real time from the time it is being broadcast. And that's the one key difference between broadcasting and, say, watching something on YouTube or watching even a rebroadcast would just be a replay of an earlier broadcast, but you are receiving it at the same time that the rebroadcast is happening. So we are now done with the 6 elements or 6 types of eligible works. And that's one of the 4 conditions, remember, that we talked about, one of the 4 conditions for copyright protection. It must fall under one of the eligible works. Now we're moving on quickly to the second condition, and that is originality. Originality means that the work must be original to the author. Now, the requirement for originality is really in connection with literary, musical, or artistic works, which we now know what they mean. So it excludes things. It excludes broadcasts, and it excludes audiovisual works, and you can understand why, because broadcasts and audiovisual works are not they're not direct expressions of the individual's creativity, right? A broadcast is really just sharing or broadcasting or transmitting content. An audiovisual work is capturing what is happening, capturing images. But with literary, musical, or artistic work, it is coming from the individual's creative mind directly. And so the law is that for you to have copyright protection for it, it must originate from you. It just simply means that it must be that you didn't copy it from somebody else. The threshold for originality is really low. It is not saying that it has to be something we've never heard of before. Oh, this story is so new. No, it's your expression of the same thing that, it could be an expression of the same thing that we've known, but the way you've expressed it, it is original to you, and therefore it is recognized as being as meeting the requirement for originality. Also, the law requires that there is sufficient skill, labor, and judgment in creating that work in order for it to be seen as being original. There is no clear definition of what skill, labor, and judgment means. And these phrases are actually more from judicial pronouncements than from legislative prescriptions. But it's generally agreed, generally accepted, generally established that you can't just say boom and it becomes a copyright work. There has to be some level of skill, some level of judgment or labor that I have put in creating that work. Now, this also does not negate what I said earlier, that the quality of the utilitarian quality of the work is not relevant. The fact that the work has such huge value to humanity is not in question, it's not material, but you have made some effort. Titles, slogans, common phrases are not considered to have sufficient original expressions. And the reason is because they are considered to not have sufficient skill, labor, and judgment. But I would say this, that in determining whether any title or phrase has the original character that the law requires, the law will generally think or focus on the facts, the surrounding facts around it. An interesting case is the case of Exxon Corporation and Exxon Insurance Consultants Limited. Here, the court held that, the Exxon Corporation had sued for infringement of copyright. And the court held that the word Exxon, which is an invented word, which is a coined word, has no meaning for itself. However, in order to give it substance and meaning under copyright law, it must be accompanied by other words or used in a particular context that gives it its meaning. Excuse me. And so that's just an indication that sometimes even titles of films, because sometimes you see films that have identical titles, the way to protect words and phrases is to use the trademark system. So you get a trademark protection for it. But if it's just a title, most titles would be too short for the court to consider them to have sufficient skill put into it. The next requirement is fixation. Fixation simply means that the work will not be eligible unless it has been reduced into a fixed format, unless it has been fixed in the medium of expression. The way the Act says it, it says a literary, musical, or artistic work will not be eligible for copyright unless the work has been fixed in any medium of expression that is presently known or later to be developed, from which it can be perceived, reproduced, or communicated. Now, this is important because if the work is not fixed, how do you prove it? Remember that copyright is it vests automatically. Excuse me. Copyright vests automatically. And because it vests automatically, I can create a work in my bedroom and nobody else but me would know that I have created a work. The only way I can prove that I have that work is if I have written it somewhere. And that's why copyright will not attach itself to anything, any idea, no matter how brilliant it is, if it is not expressed in writing. Sorry, it doesn't have to be expressed in writing. If it is not expressed in a medium, so it could be in writing, it could be recorded, like we are recording this session. If we were not recording this session, anything I say here cannot, and there is a case that we'll look at, cannot be the subject of a copyright infringement because it's all gone. It's not documented. It's not recorded. So it could be recorded. It could be printed, whatever it is, however it is captured, and technology will keep on expanding the ways in which you can capture things. The important thing is that it can be perceived, it can be reproduced. And so when you say someone has infringed on my right, the court needs to be able to say, okay, what is it that you had? And you can't say, oh, what I had was something in the past. What I had is, I just said it, I can't remember it. You must be able to reproduce it. And so an unrecorded song, an unrecorded story, and an unrecorded lecture will not be eligible for protection. And that was the crux of the matter in the case on the screen, Abernethy and Hutchinson. The court refused to grant an injunction to prevent the publication of oral lectures which were delivered by the plaintiff because the plaintiff could not provide the notes. In that case, the plaintiff could not find the notes actually from which he delivered the lecture. And so the court said it will not be, it would not be protected. Next, to look at nexus, and this is the last thing. This nexus, yeah. There must be some nexus with Nigeria, we said. The author or one of the authors must be a Nigerian or must be resident in Nigeria. Or if they don't meet any of those requirements, then it has to be that the work must have been first published in Nigeria. If none of those three requirements are met, then it has to be that if it's a sound recording or a broadcast, it was transmitted from Nigeria. And so this is where I will highlight what international treaties have made possible. Because like I said earlier, copyright laws are deeply embedded in the provisions of national legislations. But if you write a book, I mean, especially in today's digital world, you write a book or you have a song, you're likely to have it, cross borders. Are we now going to say that it won't be protected in Ghana, in Kenya, in the US? To cater to that kind of deep unfairness that would occasion if we do not have a system that ensures that works are protected wherever they go as much as possible. Countries have signed up to copyright conventions, and the most popular, the one I would highlight for this particular purpose, is the Berne Convention. The Berne Convention is a convention, it's an international treaty on copyright to which almost all the countries in the world are members of. And copyright will be extended to that, under the Berne Convention. A critical part of the Berne Convention is what we call the reciprocity requirement, which requires member states to recognize and protect the works of other member states within the works of other member states that make their way within the territory of a particular country. So when it comes to copyright protection, under the Berne Convention, it is literally possible, and in fact, not just possible, it is the situation today that if you have a copyright work that is protected in Nigeria, and you take that work to Ghana, take it to Kenya, take it to South Africa, take it to the US, take it to the UK, because these countries are all signatories of the Copyright Convention, the Berne Convention, under which they have agreed to respect and protect each other's, to respect and protect works coming from each other's country. Your work will be protected just as if it was in Nigeria. So that takes care of the difficulty that can come from the territoriality of intellectual property rights. Now let's talk about the nature of copyright, the nature of the rights conferred by copyright. I did mention earlier that there are two types of rights, largely two types of rights conferred by copyright: economic rights and moral rights. And now we're going to explain these two rights. Economic rights really are the rights that underpin the commercial value that is derivable from copyright. They are exclusive rights. We all know that by now. And these rights are highlighted under the Act as the exclusive right to reproduce. So you have a copyright work that is eligible. Once you establish that it is eligible, it is fixed. You have nexus, it's protected under Nigerian law. The author has an exclusive right to reproduce that work. Which is why, like I said earlier, if you have a book, you bought a book, you can do anything you want to do with the book, but you cannot reproduce it. It's also the exclusive right to perform the work in public. You can do anything you want to do with a book, but you cannot perform, if it's a literature, you cannot perform it in public. If it's a song, you can't perform it in public. That's an exclusive right of the author. You can't create audiovisual versions. You can't create, oh, I read this book, I like this book, and I want to act it out. You have to get the rights, or sorry, the permission of the author, because it's one of the exclusive rights of authors. The right to broadcast, the right to communicate the work to the public, the right to deal in any translation, to translate it. Oh, I love this book. I read this book, Chimamanda's book, Americana. I think it would be nice to have a French version of it. And you say, oh, after all, it would be my expression of the work in French. No, she has the exclusive right of translation. She has the exclusive right to distribute to the public, to adapt it. So those are the economic rights. And how do these economic rights, or why are they even called economic rights? It's because the way the creative industry works, when someone needs to access these works, to publish them, to reproduce, they must approach the copyright owner to get a license to do those things that are exclusively within the realm of the copyright owner's rights to do. And typically, in doing that, in giving that permission, the copyright owner will get value, will get some commercial advantage. And that's how the system, the creative industry works. And think about music, think about film, think about books, think about anything really in the creative industry. It is built on that quid pro quo understanding. You want it, you want to enjoy the value of this creative expression, you give me value for it, and that's how we create an industry, we create an economy. Now, on the other side is our moral rights. Now, moral rights are non-transmissible during the author's life. That's what the current act says. Moral rights are rights that attach to the individual, the personality of the author of the work. And there are two main types of moral rights: the right to paternity and the right to integrity. The right to paternity is the right to claim authorship of the work. It is the right to be named as the author of that work. And so if you have any work that you've copied and you have presented it like it's yours, you are actually infringing on the right to paternity, the author's right to paternity. And then there's the right to integrity, which is the right to object to any distortion, any mutilation, any not misrepresentation, I would use the word, any representation of the work in a way that can impact or damage the reputation of the author. So for example, you write a book for children, and someone uses that book in an X-rated film, for example. The moral value that you were trying to convey in writing that book for children is compromised by the context in which that person has used the book. And your moral rights, particularly your right to integrity, will be the basis for you to say, no, you can't do that. You can object to it. The Copyright Act also recognizes the right to object to false attribution. It means that if someone has written an article and the article is fraught with errors, inconsistent, the legal positions are not clearly stated, and they put your name against it, you have the right to say, no, that should not happen, and you can take action. And that's an interesting introduction in the current Copyright Act, which did not exist in the previous Copyright Acts. So I think that's progress for our copyright regime. Now let's talk about authorship and ownership. And I'm doing a time check so I can leave enough time for questions. Authorship and ownership. There's a difference between authorship and ownership in copyright law. And I'll need you to pay attention because this can be tricky. An author is the person who the law recognizes as being the originator of the work. And we would, as we would see on the slides, there are specific delineations or designations on who will be an author of a particular work. And the owner is the person who holds the right to who holds the copyright. Now you would wonder, how are they different? How can you own the rights of authorship and not own the rights to the copyright? Again, these are commercial issues. But the starting point in explaining these issues is to say that the author, like I said in the last slide, the author has an inalienable right to be recognized as the author of the work. The author is always the initial owner of the copyright, but the author has a right to give out ownership to someone else. So whilst authorship will always remain with the author, the rights of authorship will always remain, the economic benefits can be assigned, can be licensed, can be given to somebody else. And so you can have a situation where, and in many cases, there are situations where authorship and ownership are not vested in the same person. Let me give you an example in the publishing world, book publishing. Oftentimes, the book publisher will ask for an assignment of the copyright in the manuscript. And in exchange for that, there's a commercial arrangement with the author of the work. So you can have an author who is not necessarily the owner of the copyright in the book. Now, the big question we need to ask is, who is the author of a work? I've given the general principle, right, which the law uses to determine who the author is, but the law is also very clear on who the author of specific works would be. I remember authorship is inalienable. It is not transmissible. That's the language of the 2022 Act. If it's an audiovisual work, whoever made the arrangement for the audiovisual work is the author. Whoever made the arrangement for the audiovisual work, in reality, this would usually be either the producer or the executive producer, and it can be a question of fact who was actually responsible for bringing together all the parties to the film project and ensuring that everything was done properly. Whoever that person is would be the author of the audiovisual work. How about photography? A photographic work will be authored by the person who took the photograph. Oh yes, not the person who posed for the photograph. So you can pose for a photograph. And I remember having a photo shoot, and weeks after I saw my picture in the photographer's display board. I mean, we'll come to that. There are issues around that. But when it comes to ownership of the photographic work, the photographer owns it. Sound recording, again, the person by whom the arrangement of the sound recordings were made. In the music world, it would be the record label many times. Of course, these things are defined by the practical issues for each particular instance. But generally speaking, the arrangement for a sound recording will be made by the record label, and the record label will be the author. And where it's a broadcast, the person by whom the arrangement for the making of the transmission was made. Still on this issue of authorship and ownership, like I said, generally, initial ownership vests in the author of the work. Now, this is very important because people often think that if I have paid for this work, I therefore own the rights. I'm the owner of the rights to the work. No. Remember when we started out, I asked a question: is payment necessarily a conclusive indication that you own the right to a thing? No. You pay your rent, you don't necessarily have rights to the house. You don't own the house. And so it's the same, in the same way, right? You pay for a service, you pay a ghostwriter to write your autobiography. You cannot assume that you own the rights to the book because it's your story. No. Or you paid such a large sum to have this consultant develop a manuscript for you, or to develop policies for your company, and you assume that you own it. No. The exception to this is when work is done under a contract for service or employment by government, then initial ownership is vested in the government. And the current act walks away from an exception that existed in the previous act, which allowed for certain exemptions under some employment arrangements. But I don't think I need to go into that so that I don't create any confusion. The point is, if you did not author a work, the only way you can own the right to the work is by assignment. So copyright owners may grant licenses, they may transfer, they may assign the rights. And they can do that like you can do with any other property. And what is interesting about copyright is you can slice it up. You can slice up the rights and assign a part or a portion of the rights. So you can have, you've written a book, that book, you can give you can give a license to a publisher in the UK to publish the book in Europe, and give another license to a publisher in Nigeria to publish the book in Nigeria, and give another license to a film production company in the US to make a film out of the book. This is the beauty of copyright, because what you've basically done is like a slice of bread. You have sliced the rights that you have into tiny bits, and you're able to create commercial, to gain commercial value by giving specific rights. You can even time it. You can say, oh, these rights you have this right, or you have this license for 5 years. After 5 years, it reverts. And so you can be creative in how you license or assign the rights in copyright. An important point is that all copyright assignments must be in writing. All, no exception. You cannot have an assignment that is not in writing. And so I remember an interesting case where a client reached out. They had developed a unique software to run their operations. And the software was written by someone who was on their team who had now left for a competitor's company. Now, the individual went to the competitors and replicated that software. And so the client came saying, wow, what can they do? And in the final analysis, because they did not have an assignment clause in their employment agreement, there was no written clause anywhere that conferred or transferred or assigned the rights, the copyrights in the codes that that individual had written to the company. The company paid his salary, they employed him to do that job, but at best, they would have a license to use the software. They cannot prevent him because it wasn't assigned. It wasn't the company's. And I scared them a little more and I said, in fact, that guy might be able to stop you from using it if certain facts are put forward. This is why, as lawyers, it is important that we stress to our clients the need to contemplate intellectual property in every engagement. Employment arrangement, contracts, vendor arrangements, because if any copyright work is produced for you or for the company or for your client, and your client doesn't have a written assignment in their favor, they cannot claim the rights to that work. Now let's move on very quickly. This is clearly a repetition. Did I go back? Okay, I think I did. All right. Some misconceptions, and I think I already touched on this, so I won't dwell too much on it. But I have seen, and you may have seen, people draft agreements where they put the words work for hire as a basis for conferring copyright in the person who commissioned the work. Now, the concept of work for hire is not known under our copyright jurisprudence. It's an American concept. And this is what happens when clients go online and copy templates without speaking to a lawyer who understands the issues. Work for hire under the US copyright laws would enable a person, an entity that commissioned a work to own the rights, the copyright in that work on account of the fact that the person delivering the work, the author, was hired for that work. Under Nigerian law, there is no such provision. So like I've said earlier, and I'm restating it, if you do not get a copyright assignment in writing, you may as well have forfeited any copyright claim to that work, even if you paid the world for it. The other issue here is ownership of tangible embodiment of the work. And this I have explained earlier, so I won't dwell on it so we can create time for questions. But just generally speaking, we now know that if you own the tangible embodiment of the work, if the consultant has delivered to you a 55-page, well-written report that will define things in your business, and you don't own the copyright to it, you cannot do certain things with that work. You might have a license, right, which the law might read into it, but your rights over that work is limited. Again, this is where contracts that include IP provisions are critical for any business. Okay, as we wrap up, let's talk about performers' rights. Now, performers' rights are different from copyrights. Performers are persons that contribute to the creative space by making copyright works come alive, making them available to the public. So you think about the singer who perhaps did not write the song, maybe even wrote the song, but is now performing the song. You think of actors, you think of spoken word orators, they are bringing the copyright work to life, and the law recognizes their work, their input, their creative contribution, and protects it as such. Now, unlike copyrights, performance rights are not predicated on fixation. Remember, we said copyright work has to be fixed in a medium. For a performer, the right doesn't have to be fixed in a medium for the performance right to be protected. The performance right will be protected as long as they are performing, and they have the rights they have are limited, but it includes the right to exclude the fixation, exclude others from recording their work, reproducing their performance, rebroadcasting, or rather broadcasting their performance or streaming their performances. And performers may also object to any distribution or reproduction of any fixation that is not authorized by them. For example, if a person is performing and without the performer, a singer is performing without the singer's authorization, someone in the public, in the crowd, in the audience is recording that performance and then now wants to distribute it, the performer has the right under the law to stop that. The performer also has the right to object to any reproduction that is outside the scope of the consent she gave for her performance to be recorded. So, for example, if we have a recording like this, there's consent for the recording to be used for educational purposes. If the recording is used for purposes that are outside of that, then a performer's rights is infringed, and there's a place to take action against that activity. Now to issues around enforcement. Actually, before we do talk about enforcement, let's talk about copyright infringement, and then we'll come to enforcement. An unauthorized act constitutes a violation of a copyright holder's exclusive rights. An unauthorized act that infringes, that breaches, that violates the exclusive rights, any of the exclusive rights that a copyright holder has, is an infringement. Remember what those rights are: reproduction, right to communicate to the public, right to adapt, right to translate. Any of those rights that are exclusively within the realm of a copyright holder's rights to exercise will amount to an infringement if it is done without the copyright holder's authorization. And what is interesting is, like you have with property, with trespass, it is a strict liability offense. An infringer will not have a right to, an infringer would be liable even if he was unaware that what he was doing is illegal. Excuse me. Something else to mention here is that the quantum of infringement is immaterial. It doesn't matter if it was, oh, I only infringed for 1 day. Oh, I only copied it I only made 1 copy. It doesn't matter. It's a strict liability offense. Once there is an infringement, there is liability. And this is important when you are thinking about distribution of content. So you have a client who is a streaming company or a streaming platform or a TV company, and they stream and broadcast the content of others. They expect that they are getting the rights from the copyright holders, but if there's any question as to the authority of whoever has given them the content, it cannot be a defense to say, I did not know. And that's why for distribution companies, publishing companies, newspaper houses, broadcast houses, it is critical to have very tight contracts that limits that creates indemnification in the event that there is an infringement claim, because there could be, and they are susceptible to infringement claims where the content is being distributed without authority. Now, who can sue? The copyright owner can sue, an assignee can sue, an exclusive licensee can sue. Those are the three classes of persons that the law recognizes. And what reliefs are available? If you can have damages, there could be an injunction, and injunctions are very popular in the copyright field to prevent further proliferation or reproduction, or just to prevent even the copyright. So you can have a copyright action that is preemptive, right? And you get an injunction to prevent the actual infringement. And then you could also have accounts of profits where the court will make the infringer to give account of the profits that has been made from that infringement, and that profit is repatriated or given back to the copyright owner. Now let's talk about enforcement, and we'll wrap today's session. I'll take questions. When it comes to enforcement, one of the exciting things that the Copyright Act of 2022 has introduced is takedown rights. I didn't specifically mention this, but one of the rights that the Copyright Act, the 2022 Act, has introduced is the right to prevent digital access to copyright content. And that's a response to the reality of today's world. Now, in connection with that right, the owner of a copyright can request a service provider, an internet service provider, to take down or disable access to infringing content that is hosted on the system. And it could be an internet service provider, it could be a host, it could be like a Facebook or any platform that holds content and publishes them. Now, the takedown notice, there's a whole procedure for the takedown notice in the Act. But the important thing I want to highlight here is that once a takedown notice is issued, the service provider is under obligation to notify the subscriber who is responsible for the content in question. And the service provider there's a time frame for the subscriber in question to respond to it. But if the service provider fails to take action, the service provider will be liable for infringement if it fails to comply with the takedown procedure. So this puts an additional burden on service providers to do all that is needed to do timeously and expeditiously to ensure that when there is a genuine takedown request, and there's a process that allows them to also check out the facts and confirm, but to not do anything would be to expose themselves to infringement claim. And this will be the very last slide. Duration of copyright. The duration of copyright, 70 years after the death of the author. For joint copyright is 70 years. For film is 50 years. So copyright doesn't last forever. It has a time frame, but that time frame is usually tied to the life of the author. I think that's the most important thing to highlight here. And in conclusion, I would say that copyright is the foundation of the creative economy. It protects the rights of creators, and it helps, it lubricates the wheel of innovation in the creative industry. And there is value in every copyright work, and it should be protected, and it should be recognized. And we as lawyers are entrusted to do that. And I hope today's session has given you some insight into copyright laws. And that's the end of the formal presentation. I'll now open the floor for questions. Thank you.
Thank you very much, Ngozi. This has been fantastic, enlightening for me who practices in the field, and I'm sure for every other person. And okay, I think Idris is not here. Okay, so we're going to just take questions. I don't know if we'll be able to take all the questions, but the first question is a question that has come up over and over again since we started this presentation, which is who are the ideal clients in the copyright practice area. Before you answer this question, it's one of the questions that has come up, almost every day, where people are looking to see, okay, so this practice area, how do you build clients in this practice area? How do you, I think when Chinasa was on, when Chinasa took her session, one of the things that we discussed was the fact that this is all we do. Ngozi, I have known you since, you started practicing. This is all we do. And so other than telling people how to go about getting clients, but this is what we do. We have, a client base. This is our expertise. So if you want to throw more light, also give your own opinion as to that question. How do you get clients? So basically, how do you build an IP practice?
Thank you, Nta. I think that's a very important question, and it's a real question. So I would say that intellectual property in Nigeria has come with, well, the practice of intellectual property in Nigeria has come with a lot of education and awareness, because many people do not even understand what it means, what role it plays, and how it affects their business. So in my experience, and I will speak first of my experience and my journey as an intellectual property expert, I've had to do a lot of education, a lot of awareness, throwing light on how businesses can grow or thrive or can be shortchanged because of intellectual property issues. And so as lawyers, we are first teachers and educators. Many business owners don't reckon with intellectual property. They don't believe that they have intellectual property. They don't believe it affects their business. And so the first thing to do is to communicate your value, not as the way we typically do it as lawyers, where it's a compliance thing. Communicate it as a value addition. Communicate it as what your client needs to, or whoever the prospect needs to take care of, otherwise it could hurt them. So when you tell, like the case I discussed, where a very established company has lost a significant intellectual property, it's going to affect their business. They built that software, they invested in it because they wanted to use it as a competitive advantage. Now that advantage is gone because somebody else, a direct competitor, has access to it. It has a direct business implication. And so the way to get clients in this space is to communicate the value from a business point of view. And every businessman, every businesswoman wants to guard their business. And once they can see the value, they would listen to you. In some other cases, you have to show what they will gain, right, from harnessing their copyright or intellectual property properly. If you're speaking to someone who is a book writer, for example, many times they just sign whatever the publisher gives to them. But you can tell them, look, you don't always have to assign all your rights of the books to your book to one publisher. You can reserve this, you can negotiate this, and we can create additional value, additional streams of income. Those are the things that become the baits, if I would use that word, the baits that potential clients would latch on and say, okay, let's have a conversation around this. And so, generally, I would say that there's a lot of education that needs to go into the industry. And whoever educates is more likely to have the ears of the industry players.
Ngozi, thank you. This is an excellent point, which I don't think any of us, the last three speakers actually alluded to. And this is a fantastic point. When you educate, my God, I would happily hire the person who tells me about something, who tells me the reason why I should do something. So thank you very much. I hope we're taking note of that. One question is, which country will you file a case of copyright? Will it be a country of originality or the copying country?
Okay, so if you're filing a case because there has been an infringement, you would typically file in the country where that infringement has happened. But you do know that when it comes to the same principles that come to play when we think about forum, would also come to play here, right? Could be the location of the defendant, right? Where did the infringement happened. So you would have options based on civil procedure requirements as to where you should institute the action.
Okay, so for everyone who is asking for the slides, yes, they will be posted on the YouTube channel. Everything is going to go out, all the slides from the beginning of this series, and yeah, it will be posted. So what happens if someone steals my work? I don't know. That question has been answered in the point of this lecture. I don't know, Ngozi. That's the whole point of this lectures, I believe. So, is it something you want to answer, or we can move on to to the next?
I think I'll just say, I mean, I believe we are lawyers on the call, right? If someone infringes a lawyer's work, you know what to do. You have the rights under the law, and you take action.
Okay, so there's a very interesting question. So the question is from Afolabi. He says, for musical works that require clearance from the copyright holder or holders, where they are joint owners or featured artists on the musical work, if there is no contract between the copyright owner, is it legal and valid for one of the copyright owners to license the work to a third party, in view of the Copyright Act that states that an act done by one is seen as a grant given by the co-owner?
Okay, I think we need to break that question down.
Yeah, we do.
And if it's even possible to put in the chat, I don't mind. But I want to understand the context. Or do you want to read it again?
I think if Afolabi, just hold on. It was an interesting question. That's why I wanted it to be read out. Sorry, that's why I took it, because so I'm going to take it again. For a musical work that requires clearance from the copyright holder or holders, if there is no contract between the copyright owner, is it legal and valid for one of the copyright owners to license the work to a third party? So I'm imagining that if there are more than one owner, can one person act, when there's no agreement in place, can one person act for, and then it will be the action of, all the parties? That's what I understand the question to.
Okay. And I think I understand the question. I'm trying to read the exact provisions of the Act, but the answer to that question is yes. It's a yes, because the law is clear that a co-owner has as much right to the work as the other co-owner. And this is where in copyright law, contracts are everything, because you can vary almost anything with contracts. And this is where we must emphasize that it is important for contracts to be in place so that there's clarity. Otherwise, this kind of things can happen, and the law the law makes provision for that.
Okay, so another question is, I understand that moral rights cannot be transferred or assigned during the lifetime of the owner. My question is, can moral rights be waived under Nigerian law? I know some jurisdictions, the rights can be waived and stated in writing.
Okay, under the previous Copyright Act, moral rights, the language used was that it is inalienable. Under this Copyright Act, the language used is that it cannot be transmitted. Now, you can waive something without transmitting it. To waive simply means I'm not going to exercise my rights over this thing as far as you are concerned. So I could say, oh, Nta, I love you so much. Whatever you do, I will not take action against you. It's my prerogative to do that. And that's a waiver. That's different from me assigning or transmitting or any of that. So yes, what the creative lawyers do is to word provisions that prevent the copyright owner from exercising the rights against a particular person, the contracting person, which essentially becomes like a security or a safeguard for that person.
Okay, so I'm just trying to make sure that, because we don't have a lot of time to take all the questions and go with Ngozi, we just have about 19 minutes, so I'm just trying to ensure that there are questions that for most of these questions, the questions that most of them that I'm not going to ask Ngozi, if you go back to this lecture, if you go back to YouTube and listen to it, you will know, you would see the answer. And if you also go back to the other recordings on YouTube, you will generally, like Ngozi said, we're all lawyers, so we're learned people, so we should be able to catch what this is. Because like a question like, will it be okay to ask for the basic difference between copyrights and other IP, especially patent and trademark? If you've been here or you've been here since last week, you would understand that, you would know, the answer to that question. And if you go back and listen to this, you will, generally understand the question. So where a singer is paid to compose and sing a song for featuring in a film, having given the concept of the song and paid for same, does the person who paid for the composing and singing the song have copyright, or is it the singer? Can the person who paid for the song have exclusive rights to feature the song on social media? Again, but Ngozi, please go ahead.
I think the straightforward answer is it's not a case of he who pays the piper owns the copyright. There has to be an assignment. So even if you gave the prescription, this is how it should look, you have to have an assignment. Otherwise, you can't exercise those ownership rights like putting it on social media without the authority of the singer. I'm just trying to keep it simple so we can take as many questions as possible.
Like I said, if you've been here since Wednesday, the court jurisdiction is the Federal High Court. We've said it over and over again. We've been saying it since the first day, right? So, Ngozi, I think I know if this person was listening, he would understand this, he would know the answer. But with respect to copyright infringement, is it permissible under the law for academic purposes to reproduce a work without the author's permission to some persons? The person didn't word it well. Is it permissible under the law for academic purposes for you to reproduce a work for academic purposes?
So something I didn't touch on, right? And to be fair, there's no way to exhaust copyright in 2 hours, not even in 1 day. Is I didn't touch on fair use, the exceptions to copyright, to the rights under copyright. Fair use is one of those exceptions. And under fair use, if you are using a copyright work for research purposes, the law will generally provide an exemption, right, from infringement claim. So that's the straightforward answer to that.
And if the person was here, the person would understand. If we say copyright is tied to the life of the author, does that mean the right ceases to exist when the author dies? This has been answered because it just.
Okay, so copyright, the life of the author is the duration. So rather than say 10 years, 20 years, the law has given a formula for determining when copyright expires. So intrinsically, the answer is yes, right? If that timeline has lapsed, the copyright then lapses. I don't want to go into some technical maneuvers that, people use to extend the life of a copyright work, but I think that would be outside scope here. But the general straightforward answer would be yes.
Where there is a dispute between a record label and a musician, can the musician lay claim to his work? Is there anything like equitable ownership just in case?
Is there anything like what? Sorry.
Equitable ownership just in case.
Okay. I'm sorry, please, can you take that question again?
Sorry. Where there is a dispute between the record label and the musician, can the musician lay claim to his work if there is anything like equitable ownership in this case?
I think the question is a bit confusing. There are a lot of things that are not said, right? Because if there's a contract between the record label and the artist, that contract would definitely say a number of things that we cannot assume here. But an artist can lay claim. If I understand, I'm trying to understand the crux of the question. Is the question whether the artist has a right aside from the sound recording right of the record label?
Yes, that's what I think he's asking. So
Okay.
where this is what I understand from the question. So you have a record label, and then of course you fight like they usually do fight. Can he still make claims to his songs? Yeah. Yes, that's what I think.
For one, your right of authorship will continue to remain with you as a writer, right? Or as a singer if you wrote the song. Whatever your contract with usually the issue is a contract issue, is that you've signed off all your rights. That's a typical thing we see play out. But if that's not the issue, the sound recording rights is the right that the record label has. They have the right to the record, which is the means through which people are going to consume your song anyway, right? So they have the right to the recording. It is theirs. They are not, the law confers it on them. In fact, under the old law, you could even have you could argue that the artist could have some right, but under the present law, the right is situated with the record label. But you have your other rights. You have your performance rights. You have the right to the lyrics if you wrote the songs. You still have certain rights that are not the sound recording rights. So there are two different rights, or well, maybe more than two different rights that we're talking about here. And depending on the contract, some contracts you may have signed off everything, but if you haven't signed off everything, you would still ordinarily have those other rights to go home with.
Okay, so this is a question that I think, it's been answered if the person was listening, but I think we should just stress the point. It says registration of rights by the Copyright Commission is mere notification. Are you saying it is needless to have copyright notification?
No, I wouldn't say that. It is useful. It serves a different purpose from conferring the rights on you. So you have the rights. Think of it like when you have the rights to a property, you do want to go to the registry, the land registry. The law requires you to actually to document your ownership rights, right? That's the way it is. So they have a registry that allows you to deposit your work as an indication of your ownership. It doesn't mean that if you don't deposit, you don't have the right. But if you ever need to defend to make a claim, right? Someone is infringing your work, you need to show evidence that you own the work. It helps a great deal to have your work deposited with the NCC, and then that becomes easy evidence. Otherwise, it can be messy.
Okay, so we'll just have just time for just one or two more questions. So this question is, if a photographer takes a photograph without consent and publishes it for commercial use, for example, an advert, can we say there is an infringement of copyright?
Okay, so that calls on a different kind of right, which we generally call image rights. But really it sits under common law. It sits under, depending on the number of things that come to play. but not necessarily copyright. To answer your question, it's not necessarily copyright, but you definitely do have some rights. It could be a right under privacy law. If you are a popular person, if celebrity, and the person is passing you off as having something to do with their business, you have a right under tort, a right for passing off. So there are options that the law provides, but not necessarily copyright.
So, would an infringer's claim of fairness under the exception rule avail him, whereas he makes huge financial gain from the infringement?
It's not likely.
It's not likely.
Not likely. It's not likely. The nature, and I mean, I thought about bringing that in, but I couldn't really, I wouldn't have been able to exhaust it within the time. But the nature of matters that would fall within fair use are such that they are not for commercial gain, right? So if this person is doing it for commercial gain, it's very likely, the facts would tell, but it's very likely that it would fall outside the scope of fair use.
This is a very funny question. You know, when I saw it, I actually laughed first. It said, if you ask ChatGPT to compose a poem for you, who owns the rights to the poem? Because it's funny to me.
Okay. I mean, it's an interesting question, and I'm happy to answer it. I'm actually happy to answer it. ChatGPT is actually working or creating content based on data that it's been trained on. Now, the question is who owns it? Straightforward answer is ChatGPT is not a human being. ChatGPT doesn't own it. You did not generate it. You don't own it. So we can settle that matter easily. There was an interesting case that raised this issue around.
I don't know what I hear because I can't hear her.
I can hear Ngozi. Sabina, I can hear Ngozi. Are you there?
Yeah, I can hear you, but I can't hear Ngozi. Ngozi,
I can hear you.
Okay.
Exactly, Ngozi.
Okay, that's fine.
Okay.
Everyone. Okay.
Okay, go on, Ngozi.
Okay, I was just highlighting that there's an interesting case around, and these issues have come up because AI is everything now, but it's around the question of who owns the copyright in a work that is supposedly created by a non-human. And in this particular case, this is many years ago, before AI, a monkey, a researcher went into the bush, set up his cameras to capture animals, and a monkey or an ape was curious and went to it, and he clicked on the camera button and took a selfie, which was a pretty selfie, right? And the question was, who owns the rights to that photograph? Because remember, with photography, it's the person who takes the picture. The monkey in this case took the picture. Does the monkey own the rights? And the US courts held, and I think it's consistent, that copyright rests in individuals. So ChatGPT is brilliant. It's a machine. It doesn't, as at now, our laws would not allow us to give it any copyrights.
Okay, unfortunately, that's all the questions that we can take. But just as my own closing remarks, I wanted to ask Idris, do you have Idris is one of the directors of the Practical Training Academy. Idris, please, do you have any comments? Do you have any, closing remarks or questions?
Okay, just to thank Ngozi immensely. I sat through most of your presentation, and it was like taking the course of copyright, like from the basics. And I'm sure a lot of us have gained a lot from the depth of your knowledge. I just wanted to add to the issue of AI generated content, images. As you're aware, as you rightly pointed out, AI is like a subject matter across board for almost everybody. Just to add to your answer, in fact, I was just waiting to see if anybody would ask that question or if Ncha would have picked that question up. But again, yes, you're right, they are not humans. But one very critical factor, and which is what I would advise all of us to look out for, is the terms of use of these AI machines. They have very, very crafty very intelligent lawyers. So if you are using the free version, they might restrict some of your rights to it. Facebook and Meta has tried to do it before, to say that all content generated on that platform could be, they were trying to claim ownership, but they saw the backlash and they withdrew. But right now, as it stands with OpenAI, even with all Google AI service products, it's the terms of use. And the terms of use are quite clear that you own anybody that has used that AI tool to generate any content owns it for now. I'm sure later on we could see how the law develops in that area. Interesting again is the current ongoing case in America with Midjourney and Disney World. Midjourney is also an AI tool that you can use to generate videos and so many other things. Basically, videos you can use to generate, and they've taken Disney and Universal has taken them to court, and I think it's still pending, and challenging the use of that Midjourney to create characters that were very much in line with characters that Disney had already previously created. So while I agree that they are not they are machines, but it is creating a new and very, very important vestor as it stands in copyright rights. But in a nutshell, I'd just like to say a huge thank you to you, Ngozi, on behalf of the Practical Training Academy, that you've done a yeoman's job. I'm going to look for your slides and I'm going to watch it again in order to revamp my knowledge on copyrights IP rights. Thank you very much and well done.
Thank you, Idris. For me, as my closing remarks, I just wanted to say that for all the interesting questions that have been asked, Ngozi had mentioned that, one of the ways for you to grow grow in the IP space is actually to teach, but you won't be able to teach without you doing the research to actually understand first. So most of these questions can be turned into, researched, and then you are able to publish it. So for my closing remarks, I just wanted to say thank you. Please, if you need to find out anything, because I believe that all that needs to be said has been said, please go back to the recordings and listen to it. Thank you, Ngozi. Thank you, Tobenna. And it is, over to you now, Tobenna. Thank you.
Yeah, thank you very much, Nta. Thank you very much, Ngozi. What a brilliant presentation. As always, learned a lot myself. I just want to say to everybody that we owe a huge debt of gratitude to Ngozi and indeed to the rest of the panelists or facilitators who have taken us through the entire IP training, and they've done this at absolutely no cost to the participants or indeed to the Practical Training Academy. And Ngozi, I thank you for all the support that you've given to the MBA, to the MBA ICLE, at the SBL level, and now to the Practical Training Academy. Thank you very much. It's not easy. I know how busy you are, and you had to join in all the way from the United States. Thank you. God bless you. And I hope that when we call you again, you will find the time to be with us once again. But thank you very much, and I thoroughly enjoyed the session. And to everybody who's participating, thank you for who's participated. Thank you for participating. I'll just say that the link to our YouTube channel is on the comment section. For those who want to subscribe, all our videos are there. We're also working on uploading all that content there so that people can educate themselves as we move along. As you know, the Practical Training Academy is a not-for-profit that continues to try to provide training and development for Nigerian lawyers and indeed other professionals in Nigeria. Towards the end of this month, from the 24th, we're going to also be having a 4-day training on taxation. And I encourage everyone to look out for the information and to also join. I hope you have found these trainings educative and illuminating as I have. So thank you very much. Thank you, Ngozi. I hope to see you soon. Thank you, Nta. And a huge thank you to everybody who's been part of the IEP faculty, and to my brother Idris, thank you. To the team from MBA ICLE, I can see Sarah and Abubakar, thank you for being here also, and God bless you all. Thank you.
Thank you. Bye.